Today is Saturday, October 15, and it's time to talk about a press release from the Cayman Islands government issued on October 13th, stating that Cabinet approved the commencement of Parts 1 and 2, as well as Sections 99 and 101 of the Legal Services Act, effective Friday, 14 October. For people who are interested in learning more about Parts 1 and 2, 99 and 101, it's useful to get a quick explainer. I remind you, of course, that nothing mentioned in this explainer is legal advice. It is just a sharing of information to help members of the public understand the Legal Services Act and why it has been so problematic for several decades. To start, Part 1 contains helpful definitions, including what activities are covered by legal services and an explanation of what it means to practice Cayman Islands law. Part 2 then deals with the establishment of the Cayman Islands Legal Services Council to regulate the practice of law in the Cayman Islands. Now, the purpose of the council, generally speaking, is not controversial. This is because everyone agrees that the practice of law should be regulated. What is controversial, however, is the composition of the council. Under the Legal Services Act, this is made up as follows: the Chief Justice, the Attorney General, several practicing and non-practicing attorneys appointed by the Premier and the Leader of Opposition. Some professionals say that the challenge with the proposed membership of the Council is that the powers of so many powerful people are concentrated in one place. This is problematic for many reasons, especially the possibility of breaching the doctrine of separation of powers. Now, if you're asking, what is the doctrine of separation of powers? Well, it's an important concept that suggests that the powers of the judiciary, that is the court, the executive, that is cabinet, and the legislature should not be mixed and should remain separate. If separation is not practiced, then too much power from different arms of government might become heavily concentrated in one place. This is not good from the perspective of good governance, especially independence. The mixture of persons from the legislature, the court, and executive on the council may also pose issues for someone who wishes to challenge the decision of the council. For example, if a sitting judge or the Attorney General is the chairperson of the council responsible for discipline of an attorney, then when that attorney challenges the decision of the council, the attorney may have questions about whether he or she will have a fair chance at trial when he or she goes to court. This concern arises because it would have been an active sitting judge on the council, chairing the council, who was part of the decision-making process to discipline the attorney in the first place. Some serious thought is therefore needed regarding the possibility of conflicts of interest between the court and the council like this. This is important because such conflicts could threaten a person's right to a fair trial. The other issue is that there are several political appointments to the council. These include persons appointed by the Premier and the Leader of Opposition. The fear in this case is that political appointees may carry out the wishes of politicians rather than to follow a strict code of conduct. While I could expand on these concerns, I think it is more useful to provide some solutions that have been proposed over the past couple of years. Number one, the council should not include the Attorney General or any active sitting judge. The council should not include any political appointees. Instead, a variety of people should make up the council, including retired law firm partners, retired audit firm partners, and other governance professionals. All of these positions should also be advertised in a transparent way and selections based on competencies rather than being handpicked. The other controversial issue is that even if the council is set up properly, the intention under the Legal Services Act is for the council to carry out certain functions imposed on the council under the Proceeds of Crime Act. That is, the council is expected to act as a supervisory authority or a regulator to ensure that lawyers stay in line with anti-money laundering and anti-terrorist financing procedures. The reason that some professionals have pushed back on this is because they say that the Cayman Islands Monetary Authority is already in place as a regulator for anti-money laundering and anti-terrorist financing measures. In fact, CIMA inspects very complex structures and assists international regulators, including the Securities Exchange Commission, to solve important crimes. Once CIMA is provided with more funding and more staff to regulate lawyers for anti-money laundering and anti-terrorist financing, CIMA will competently do the job in the same way that CIMA has been doing for big banks, investment management companies, and other complex structures. With CIMA being such an obvious solution as a regulator, it is challenging, therefore, to understand why there may be resistance to CIMA as a regulator for lawyers for anti-money laundering and anti-terrorist financing purposes. Now, I think this is a good place to stop. Tomorrow, a discussion will take place on the types of regulations that Cabinet can make under Section 99 of the Legal Services Act and the transitional provisions that Cabinet can make under Section 101 of the Legal Services Act, including what Cabinet might suggest as transitional provisions to penalize or forgive persons who have been practicing Cayman Islands law for decades without any Cayman Islands legal practice certificate.